swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God?
I do.
Let the record reflect that the witness has answered in the affirmative. Thank you. You can be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony. Mr. Smith, you may begin.
Chairman Jordan, Ranking Member Raskin, members of the committee, thank you for the opportunity to discuss my work as special counsel. I love my country and believe deeply in the core principles upon which it was founded. For nearly 3 decades, I've served as a career prosecutor in both Republican and Democratic administrations. I've handled cases ranging from domestic assault and gang violence to public corruption and election crimes across the United States, and I've prosecuted war crimes overseas. I am not a politician, and I have no partisan loyalties. My career has been dedicated to serving our country by upholding the rule of law. Throughout my public service, my approach has always been the same: follow the facts and the law without fear or favor. Experienced prosecutors know that specific case outcomes are beyond our control. Our responsibility is to do the right thing, the right way, for the right reasons. These principles have guided me through my career, including as special counsel. I'm proud of the work my team did, and I appreciate the opportunity to appear here today to correct false and misleading narratives about our work. During my tenure as special counsel, we followed Justice Department policies, we observed legal requirements, and took actions based on the facts and the law. I made my decisions without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 election. President Trump was charged because the evidence established that he willfully broke the law, the very laws he took an oath to uphold. Grand juries in 2 separate districts reached this conclusion based on his actions, as alleged in the indictments they returned. Rather than accept his defeat in the 2020 election, President Trump engaged in a criminal scheme to overturn the results and prevent the lawful transfer of power. After leaving office in January of 21, President Trump illegally kept classified documents at his Mar-a-Lago social club and repeatedly tried to obstruct justice to conceal his continued retention of those documents. Highly sensitive national security information was held in a ballroom and a bathroom. As I testify before the committee today, I want to be clear. I stand by my decisions as special counsel, including the decision to bring charges against President Trump. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in criminal activity. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Democrat or a Republican. No one should be above the law in this country, and the law required that he be held to account, so that is what I did. To have done otherwise on the facts of these cases would have been to shirk my duties as a prosecutor and as a public servant, of which I had no intention of doing. I remain grateful for the counsel, judgment, and advice of my team. President Trump has sought to seek revenge against career prosecutors, FBI agents, and support staff simply for having worked on these cases. To vilify and seek retribution against these people is wrong. Those dedicated public servants are the best of us, and it has been a privilege to serve with them. After nearly 30 years of public service, including in international settings, I have seen how the rule of law can erode. My fear is that we have seen the rule of law function in our country for so long that many of us have come to take it for granted. The rule of law is not self-executing. It depends on our collective commitment to apply it. It requires dedicated service on behalf of others, especially when that service is difficult and comes with costs. Our willingness to pay those costs is what tests and defines our commitment to the rule of law and to this wonderful country. Thank you.
Gentlemen, we will now proceed under the 5-minute rule. We have votes coming in any minute now, but I think we'll have time for 3 or 4 members to get their 5-minute question in before the committee will take a recess to go vote. They are not going to close the vote until we get there. I know that much. So we will start with the gentleman from California. You're recognized for 5 minutes.
Good morning, Mr. Smith. When Attorney General Garland appointed you, he cited the particularly sensitive matters at issue and extraordinary circumstances as the reason for appointing a special counsel. What did you take that to mean?
What I understood that to mean is I was to conduct an independent investigation and come to my own conclusions about whether the facts and the law supported a prosecution.
But clearly he was alluding to the fact that we had an investigation into a leading candidate for president. That was part of the extraordinary circumstances. Would you agree?
I will rely on his public statements about that. I understood my role as special counsel was governed by the regulations, which required me to make an independent decision on my own.
So certainly you would agree it was important to approach the investigation with humility and restraint. Is that fair?
Yes, and that's what I sought to do. I sought to
And you thought you possessed those qualities. In fact, you testified at your deposition, quote, "I thought I was the right person for the job." Of course, some disagreed. Constitutional law professor Jonathan Turley, for example, has said, quote, "Jack Smith has a reputation for stretching criminal statutes beyond the breaking point." I assume you disagree with that statement by Professor Turley.
I do disagree with that statement. I think my career speaks for itself. I have been
But that statement was also, and I'm sorry to have to interrupt, I just have a short amount of time. That statement was also echoed by the United States Supreme Court in a unanimous opinion in McDonald versus the United States, where the court overturned convictions that you had pursued against a former governor, criticizing your boundless interpretation of the federal criminal statute. At issue, that opinion was joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. So do you also disagree with that statement by those justices?
I have conducted my career in a nonpartisan fashion. That particular case, the legal position that the department took, that wasn't my personal position. That was the position of the department.
I see. So, Mr. Smith, I've had the opportunity during my time on this committee to review the work of 2 special counsels, John Durham, appointed during the Trump administration, and Robert Erb during the Biden administration. And in both cases, they seem to exhibit that humility and restraint that we talked about. But in reviewing in detail the way you conducted this investigation, I see a very different mode of operation. One that sought maximum litigation advantage at every turn, one that repeatedly circumvented constitutional limitations to the point that you had to be reined in again and again throughout the process. For example, shortly after you became special counsel, you issued a subpoena for the phone records of the Speaker of the House of Representatives over a 2-month period, along with for other senators and representatives, even though the public integrity section at DOJ cited litigation risk to doing this. What was that litigation risk?
With respect to the toll record subpoenas that we issued, they were approved by the Public Integrity Section. The Public Integrity Section, in approving those subpoenas, noted the fact that the subpoenas were for records for people who were not targets of our investigation.
But they said there was a litigation risk and you moved forward with it anyway. And not only that, but you also sought orders from judges making it so those who were having their records seized would not know about it. And you even didn't tell those judges that it was members of Congress whose records you were going after, in apparent contravention of a federal statute saying that a telephone provider for a Senate office shall not be barred from providing notice that the records had been requested. Now, if you sought to do that today, would you be able to get away with that, with asking the judges for a non-disclosure order without telling them these are members of Congress?
When we secured these toll record subpoenas, it was done consistent with department policy. You're correct in that that policy has since changed.
They changed the policy based upon the actions that you took. Similarly, you issued a gag order against President Trump that the D.C. Circuit Court of Appeals vacated as overbroad. Is that correct?
Well, the D.C. Court of Appeals, in passing on that order, found that it was justified. They narrowed the order, but they confirmed that the phenomenon—
They narrowed the order because it was overbroad. In addition to that, you sought an early trial date that the district court rejected, and when you presented your prosecution memo to Attorney General Garland, it's been reported that he was visibly unimpressed and expressed First Amendment concerns. So, Mr. Smith, looking at the record, I see that you were reversed and rebuked by the Department of Justice itself, by the Attorney General, by the Solicitor General, by multiple district court justices, judges, by the Court of Appeals, and by the U.S. Supreme Court itself. So my final question is, do you believe that you made any mistakes? Do you have any regrets as to how you conducted this investigation?
If I have any regret, it would be not expressing enough appreciation for my staff who work so hard in these investigations. We followed the facts and the law. These people who work for me sacrificed endlessly and have endured way too much for just doing their job. So if anything, I wish that I had thanked them.
Time of the gentleman.
No mistakes. There's that humility. Mr. Chair, I yield back.
Yeah, time of the gentleman's right. The chair now recognizes the ranking member for 5 minutes.
Well, thank you, Mr. Chairman. And the good gentleman from California certainly knows, because he was a student of mine, that lawyers go to court and sometimes they win motions and sometimes they lose motions, and there's no crime in any of that. And I'm just sorry that you had to be lectured about humility and restraint by a politician, because we might not be best poised to lecture you on those particular virtues. But let's go to the toll record, since that's been raised, Mr. Smith. First of all, Congress has allowed toll records to be subpoenaed. This committee has actually tried to limit it over the years, and the senators who are whining the most over on the Republican side in the Senate, they never went along with our determination to try to limit the government's ability to subpoena toll records. So it's perfectly lawful what you did. Explain, why did you want those toll records?
We wanted to conduct a thorough investigation of the matters that was assigned to me, including attempts to interfere with the lawful transfer of power. The conspiracy that we were investigating, it was relevant to get toll records to understand the scope of that conspiracy, who they were seeking to coerce, who they were seeking to influence, who was seeking to help them.
And that's normal investigative practice, right?
In conducting a criminal investigation, securing non-content toll records, as you described, is a common practice in almost any complex conspiracy.
Okay, let's go to something else that I've been hearing over the last week by our colleagues as they've eagerly anticipated your arrival here. They've been saying that there's some kind of First Amendment defense that Donald Trump would have had to the crimes you indicted him for. Is there a valid First Amendment defense to defrauding the public? Is there a valid First Amendment defense to disrupting a federal proceeding? Is there a valid First Amendment defense to violating the voting rights of the people and cheating the public out of a fair election?
The First Amendment is something that we took seriously in our investigation, but the First Amendment does not protect speech that facilitates a crime. Speech that is used to facilitate a crime, a fraud crime in particular, is not protected under the First Amendment. The Supreme Court precedent on that is clear. This is an issue that we litigated before the district court, and the district court ruled, as I just stated, that it is not in fact protected.
And the case law is perfectly clear on this, right? All frauds are perpetrated by speech, right?
Yes.
All conspiracies are perpetrated by speech. So just because your criminal conduct is brigaded with speech doesn't somehow mean you've got a First Amendment defense against trying to overthrow the government. I mean, the people who attacked the police officers on January 6th were chanting, "Hang Mike Pence." I suppose that was political speech, or they were saying, "Stop the steal." Does that mean they've got a First Amendment defense to violent assault against the officers?
It does not.
William Barr, by the way, was somebody who was perfectly clear about that. Donald Trump's own attorney general said there's no freedom of speech that you have to engage in a conspiracy to overthrow an election, to commit crime. He was perfectly clear about that. Back in those days, in fact, lots of people on that side of the aisle, including my good friend, the chairman, denounced the violence that took place on January 6th. The cat's got their tongue these days. My friend Chairman Jordan said, what happened last week was terrible, was tragic. It's as wrong can be, he said. Republicans, we know all political violence is wrong. I asked my friend Chairman Jordan at a rules hearing, are you also not interested in what happened to us on January 6th? He said, of course, everyone's interested in holding people accountable who did wrong. The FBI is doing that. The Justice Department is doing that, appropriately so. What do you think about the attack on the Department of Justice and the Special Counsel for doing your jobs?
I think the attack is unjustified. I think the people who worked with me as career public servants are people, they're part of the reason I've been a prosecutor for so long is to work with people like that, not just the prosecutors in my office, but also the agents, FBI agents who are heroes, who have served their country not only as agents, but also overseas. I think those attacks are unwarranted based on the facts, and I think that they have no basis in who we are as Americans, as a country. I don't see attacking people like that as anything appropriate.
Thank you. And Mr. Chairman, I yield back to you.
The gentleman yields back. Mr. Smith, is Cassidy Hutchinson a liar? She was their star witness, January 6th committee, their star witness in one of those staged and choreographed hearings they paid the former president of ABC News to put together. She was, in fact, the only witness at this special primetime hearing, Tuesday, June 28th, 2022, 8 o'clock in the evening, and she told some stories. I mean, these were some stories. She talked about President lunged across the back seat, grabbed the steering wheel, tried to drive the car to the Capitol. And I just want to know, you think she was lying?
Chairman Jordan, my assessment of that particular issue is that with respect to the testimony about the president lunging towards the driver, my recollection of her testimony about that is that it was secondhand. She said she'd heard that from somebody.
You familiar with the name Tony Ornato?
I'm sorry?
You familiar with the name Tony Ornato?
Yes.
White House Deputy Chief of Operations, Deputy Chief of Staff for Operations, right? You remember what he said about it?
As I sit here right now, I do not.
Yeah, he said it didn't happen. How about Bobby Engel? You familiar with that name?
Yes, I am.
Secret Service agent who was actually in the car that day. You know what he said? He said it didn't happen. And they both said the first time they ever heard this story was when Ms. Hutchinson testified in the primetime hearing as their star witness of the January 6th committee. By the way, did you ever confirm her testimony about this particular incident?
We conducted, as I said before, our own independent investigation of all aspects of the case that we thought was relevant. We, attorneys from my office.
Did you ever confirm it? That's a simple question.
Well, we interviewed her, I should say, attorneys in my office before.
Did you ever confirm the president leaping across the seat, grabbing the steering wheel, this whole concoction she brought up in the January 6th hearing? Did you ever confirm that?
Right. We interviewed another firsthand witness who was in the car, who did not confirm that had happened, but also
in your deposition to the committee last month, Mr. Smith, you said this: my recollection with Ms. Hutchinson was a number of the things that she gave evidence on were secondhand hearsay. You remember making that statement to us last month in the deposition?
I did, and I was referring particularly to what we're talking about now.
Yeah, and you also said Ms. Hutchinson regarding this particular claim was a second or even third-hand witness. We asked you, if you were a defense attorney, how would you handle cross-examining her if she was on the witness stand? And you said, if I were a defense attorney and Ms. Hutchinson were a witness, the first thing I would do was seek to preclude her testimony because it was hearsay. You remember saying all that?
Yes, that's correct, sir.
That's correct, right? Were you going to put her on the witness stand if you ever got to trial?
We had not made final determinations as to who we were going to call as a witness. We had a
You were
large,
still considering her?
we had a large choice of witnesses in this
Are you
case.
familiar what Washington Post reporters Carol Leonnig and Aaron Davis said in their book? They did this book, 300-some pages book on chronicling the whole investigation of the Justice Department. And here's what they said on page 310. They said, Jack Smith had wondered whether some of Hutchinson's claims might be relied upon at trial. Still, at one point, Smith told the elections team he wasn't ready to give up on Hutchinson's account. Ultimately, however, Trump administration officials uniformly, fiercely disputed her accounts under oath. Prosecutors on your team told Smith they wouldn't want to use Hutchinson as a witness in court, and Smith agreed. Are Carol Leonnig and Aaron Davis, who wrote this, are they lying?
My recollection is that I certainly had not made any final determinations about who we were going to call.
And
as a
that's the point. That is the point. The fact that they used her in a primetime hearing and you won't rule out using her, or didn't rule out using her, putting her on the witness stand when everybody knows she wasn't telling the truth, that says it all. That's the degree the left and Democrats were willing to go to get President Trump, putting on the witness stand someone everybody knows is making it up. Everybody knows that. And you were willing to do it. By the way, you know how many times Cassidy Hutchinson was mentioned in their report, the January 6th report? Any idea, Mr. Smith?
I do not.
185 times. Someone that the whole country knows wasn't telling the truth, and you were still considering putting her on the witness stand because you had to get President Trump. And everybody can see that. We better take a recess for votes. We will resume as soon as votes are over. Back here 10 minutes after. Mrs. Smith, you guys can go back to the room that you were in. Committee will come to order. Gentleman from ranking members recognized for unanimous consent request.
Thank you very kindly, Mr. Chairman, and this just goes to the question of the hypothetical witness at the trial that didn't happen. New York Times, May 1, 2024, Trump acknowledges he wanted to go to the Capitol on January 6th.
Without objection.
Carol Leonnig, who you quoted, Carol Leonnig outlines Tony Ornato's history of lies. That's June 30, 2022.
Without objection.
In July 1, 2022, the men disputing Hutchinson's testimony are two of Trump's biggest acolytes. And finally, June 29, 2022, CNN, Cassidy Hutchinson stands by her testimony amid pushback. Thank you very much.
Gentleman from New York is recognized.
Thank you, Mr. Chairman. Mr. Smith, over the past few years, Republicans have waged constant attacks on you. Donald Trump has said you are totally compromised, a political hitman, a left-wing radical, a criminal, a fully weaponized monster, and that you should be considered mentally deranged and thrown out of the country. Just this week, he called you a sick bastard. Unfortunately, the rules of decorum prevent me from saying what I think of Donald Trump. But he is not the only one to launch attacks against you. Chairman Jordan has accused you of abusive surveillance and accused you and your team of partisan and politically motivated prosecutions. Despite the mountain of evidence that you laid out in the Special Counsel's report and in your court filings, President Trump's supporters are convinced that the only reason your team tried to hold him accountable is because you have a vendetta against him. I want to address these allegations today. You have had a long and distinguished career with the Justice Department, including serving as the chief of DOJ's Public Integrity Section for 5 years. While leading the Public Integrity Section, you led investigations and prosecution of public figures and political leaders from both parties, Republicans and Democrats. Can you give us a couple of examples?
Sorry about that. During my time as the chief of public integrity, I investigated cases involving both Republicans and Democrats. The standard in all of those cases was the same: follow the facts and the law. Didn't matter what party you were in, it mattered the facts of the case. In doing that, there were cases I brought against Democrats and cases I brought against Republicans. There were also cases that I investigated and did not bring against Democrats and Republicans. Party affiliation played no role in my investigations. I can think of multiple cases of prominent members of Congress that we investigated who were Republicans, who, upon reviewing the law and the facts, I decided not to go forward in those cases. And the same could be said with people on the Democratic side. I've always tried to follow the facts and the law in my career.
When it comes to deciding whether to pursue a criminal prosecution of an individual, what factors do you consider?
The primary factors are the facts and the law. As a federal prosecutor, in making a prosecutorial decision, you're guided by the federal principles of prosecution, which guide one not only to look at the facts and the law, but the federal interests. And that is exactly what we did in this case, as set forth in my final report.
Does partisan politics play a role in your decision whether or not to prosecute someone?
None.
To be clear, did partisan politics play a role in your decision to charge Donald Trump?
It did not.
What does it do to the justice system if political leaders place pressure on prosecutors to file charges against their political enemies? What are the implications if prosecution decisions are based on politics, not the law?
I think it weakens the rule of law in our country because it weakens the mechanism for us to prosecute, among other things, corruption. When there is political prosecutions targeting people because they're enemies of the president, the department loses credibility and it can't do its job in all sorts of cases.
According to your deposition before this committee, it sounds like your problem was not determining if you had enough evidence to charge Donald Trump, but rather that you might have had too much evidence and struggled to determine how to present a clear narrative to a jury. How would you characterize the evidence against Mr. Trump about inciting an insurrection against the laws of this country? Did you have too much?
Well, With respect to presenting the case that we charged, one of the central challenges was trying to present that in a concise way because we did have so many witnesses. Some of the most powerful witnesses were witnesses who, in fact, were fellow Republicans who had voted for Donald Trump, who had campaigned for him, and who wanted him to win the election. These included state officials, people who worked on his campaign, and advisors. I will say, however, with respect to the charge of insurrection, we did not charge that. As I set forth in my report, while I believe that there is, courts have found that that was an insurrection and that there's a reasonable interpretation, a reasonable prosecutor could interpret the evidence to support that charge. I chose not to do that, looking at the facts in the law. I thought the charges we brought were appropriate, given the evidence that we had.
Thank you, Mr. Smith, for your decades-long public service and for working tirelessly to uphold the rule of law. Those who attack and smear you and your team in order to protect Donald Trump should be ashamed of themselves. I yield back.
Gentleman yields back. Gentleman from California is recognized.
Mr. Smith, do you see criminals to my left? You don't see any. Do you see people who are committing crimes because they continue to believe things that just aren't true? That's paraphrasing Ronald Reagan, that liberals aren't stupid, they just know things that don't happen to be true. If the president believed that he was cheated in an election, that there was fraud, or in some other way a number of items led to his defeat, when in fact he should have won according to the Constitution, does that make him a criminal?
Sir,
No, that's a yes or no, please, Mr. Smith. These people here are continuing to grapple constantly with things that aren't true, like socialism works, or that somehow everything the Republicans do is evil and everything they do is right. They've never reached a conclusion in a typical partisan case in which we're not evil because we think something different and we're not wrong. You understand the Constitution. Do you understand the Bill of Rights, that someone has the absolute right to believe something, whether it's true or not, and to advocate for something, whether it's true or not? Do you understand that in addition to your oath to the Constitution, that that's one of the things the First Amendment allows for, isn't it?
yes, sir.
Okay, so if you know that people have a right to opine, lobby for, assert, do everything they can legally to ask for people to make different decisions, then why is it you saw criminal conduct on behalf of a president who believed he didn't win? Chairman Jordan and myself have something in common, along with a number of others here. We saw wrongdoing, and on January 6th, we voted not to confirm 2 states because they had violated the U.S. Constitution in how they selected who got ballots. And yet, you're going to come here and say, oh, I just followed the law. When you went after these people and you said, well, technically I can do that, you didn't see any selective nature or any separation of powers under the Constitution to spying on the activities and the conversations of the Speaker of the House? To what end would conversations between the Speaker of the U.S. House, third or second in line to be the president, and the president, in what basis would it be any of your business other than you believe that there was a conspiracy without conspiracy as a basic premise? You, like the president's men for Richard Nixon, went after your political enemies. Maybe they're not your political enemies, but they sure as hell were Joe Biden's political enemies, weren't they? They were Harris's political enemies. They were the enemies of the president, and you were their arm, weren't you?
No.
No. Oh, great. So you spied on the Speaker of the House and these other senators and so on, and informed no one, and in fact put in a gag order so they couldn't discover it. If they were not subjects of a conspiracy investigation, why did Congress, a separate branch that you under the Constitution, have to respect. Why is it that no one should be informed, including the judges? As you went in to spy on these people, did you mention that you were spying on seeking records so you could find out about when conversations occurred between the U.S. Speaker of the House and the President? Did you inform the judge, or did you hold that back?
My office didn't spy on anyone.
Wait a second. The question I asked you, Mr. Smith, was pretty straightforward. Did you withhold that information from an Article III judge in the process of taking the records of the Speaker of the House?
We complied with department.
Did you hold back
Mr.
that
Chairman, would you
information?
please instruct the gentleman to allow the witness to answer the question?
It's not your time. I'd like my time back.
Mr. Chairman,
again,
you have
please.
repeatedly done that in the past. The witness has the right to answer the question.
And there'll be due time to answer the question. Would you please put my time back and let me finish this? Mr. Smith, I asked you a question and you were not responsive to it, and I want you to be responsive to it. Did you, whether you think it was legal or not, whether you think it was right or not, did you withhold the name of Kevin McCarthy, Speaker of the House, when you were seeking records on Kevin McCarthy, the Speaker of the House, or Jim Jordan, the chairman of this committee?
At the time the gentleman is.
No,
is- you
please
got a
give me
few more
back the
seconds.
time that
No,
was
no, no,
taken away.
Time has expired, but we're going to let the witness answer your question because it's an important question. The witness can respond.
We did not provide that information to the judge when we requested a non-disclosure order, consistent with the law and consistent with department
Mr.
policy.
Chairman, the amazing thing here today is that we have an admission that an Article
Mr. Chairman,
I-
the gentleman's time has
Come on.
expired by now 34 seconds.
It gets more than 5 minutes?
How many
'cause it's a
times you
good
interrupt
question?
me?
The time belongs to the gentleman from California, but it has expired.
I will be brief in my address to the chairman. We have the evidence that an Article I representative on behalf of the president withheld
Order,
from
Mr.
Article
Chairman.
III.
Point
Mr. Chairman, are we
that
to be granted the
information.
same leniency at
And
this
with that,
point?
I yield back in
yield
disgust of this witness.
Sticking with California, the gentlelady from California is now recognized.
Mr. Smith, thank you for being here today. Earlier, the chairman spent a lot.
Thanks for watching, and if you haven't already, please consider subscribing to our channel. And while you're at it, please leave us a comment. Thank you for watching.